Hi, this is Andrea Kane, and I'm here with you one more time for HIT 421 Legal. We are finishing off week 15 right now by tackling chapter 18. And we are working on unit objectives 9.9.1 through 9.9.13 this week and next week while we work on chapters 17, 18, 19, and 20. But since we're on week 15, it's just chapters 17 and 18. And this section will be on corporate compliance. And please don't worry, we will be covering topics like risk management, quality improvement, patient safety, corporate compliance, medical staff, workplace law. This is only the first time it's getting thrown at you. It will get brought to you again in other classes. So we're really just trying to introduce the topic here, give you some background information so that it is so that you're aware of it before you get into where we really do a lot of deep diving into it. All right, so having said that, let us go into good old chapter 18. If you want to follow along in your book, I am on page 437. 437. All righty then. Let's do it. Compliance refers to adherence to federal statutes and regulations that are designed to prevent unjust financial enrichment and patient privacy breaches by healthcare providers or organizations. So basically what we're talking about here is fraud and abuse and HIPAA violations. That's what we're talking about when we talk about compliance. All right, so what is fraud and abuse? Fraud is a false representation of fact. It is deliberate. It is the person doing it knows it is not true and they do it anyway. It is a failure to disclose a fact that is material or relevant to a healthcare transaction. It can cause damage to another party that reasonably relies on the misrepresentation or failure to disclose. Abuse, on the other hand, can be inconsistent handling of sound fiscal, business, or medical practices result in unnecessary costs to the program, improper payment, services that fail to meet professionally recognized standards of care or are medically unnecessary, services that directly or indirectly result in adverse patient outcomes or delays in appropriate diagnosis or treatment. Typically, abuse is not intentional. It just happens. It can be someone unknowingly making mistakes. It can be someone who didn't realize that the end result would result in any of these bullet points. So that is the biggest difference between fraud and abuse. Fraud, the person doing it knows it is wrong and that it's not true. In abuse, there's an element of either accidental occurrence or ignorance or that type of thing. It is not deliberate and known. Most common types of fraud are listed for you here. They include billing for services that were never rendered, billing for more expensive procedures or services than were actually provided. This is known as upcoding. And if you haven't covered upcoding in your classes with Michelle Grant, you will, or I will get to it when you get me for reimbursement methodologies. Performing medically unnecessary services, misrepresenting non-covered treatments as medically necessary, falsifying a patient's diagnosis to justify tests or procedures, unbundling, upcoding and unbundling are two that, again, if you don't get those through your coding classes, you'll definitely get them with me when we get to reimbursement and other classes. Billing patients more than the copay amount for services, accepting kickbacks for patient referrals, or waiving patient copays or deductibles and overbilling the health plan. How do you prevent fraud and abuse? Well, typically it's through what's called revenue cycle management, which is the supervision of all administrative and clinical functions that contribute to the capture, management, and collection of patient service revenues, and that includes coding. It also includes documentation. So let's talk about the role of documentation. Documentation must support billing, and it actually must support what happened. It needs to reflect what happened. It needs to be done at or near the time of event. It supports the claims. It needs to support the claims, requests for reimbursement, and it has to be complete and accurate. It needs to reflect reasonable and necessary services ordered by an appropriately licensed medical professional. All right, let's talk about some key federal fraud statutes. The big one, this one you have to know. That is False Claims Act. The False Claims Act actually came about back in the 1860s during the American Civil War. It happened on the Union or northern side of things, where there were factories producing firearms and cannons, and they knew that their equipment was substandard. They knew that what they were producing could explode and harm the men who were manning the cannons or using the firearms. And they sold them to the government anyway. The False Claims Act came out of that you cannot knowingly provide a substandard service or product to the government or to people that are acting on behalf of the government. And so for a long time, the False Claims Act pretty much was in a dusty old book in a corner. But when healthcare reached a point in the 70s, 80s, 90s, where there was activity going on, where there was Medicare, Medicaid fraud happening, the False Claims Act was revised and updated. And it has become the central statute, federal statute, that is used now by the government for going after healthcare organizations and providers for fraud and abuse. So that's why you need to know it. So again, it's the primary litigation tool for combating fraud, and it contains both criminal and civil provisions. We will be covering this, as I said at the beginning, corporate compliance, this is not the first time you're going to hear it or the last. But this is a point where it's really important because it is a statute, it is a law, and this class is all about statutes and laws, that you need to be aware of it. All right, so it is for combating fraud. It contains both criminal and civil provisions. It also contains a provision about whistleblowers, or qui tam. Qui tam. Make sure you know that term. Hint, hint, hint. Someone who is involved in an organization where there is fraud or abuse going on, and they take their concerns through the organization, and the organization does not fix things, that person can go to the federal government and file as a whistleblower, and they file a complaint, and they allege that fraud is being committed against the government. If the government then protects the qui tam or whistleblower, and they cannot be fired by the organization or harassed in any way. But if the case goes to court and is found to be true, and the healthcare organization is penalized, the whistleblower under qui tam can get a percentage of that money. So there is a bit of a financial incentive there for people to be involved in that. But on a professional basis, you need to be able to prove that you went up through the organization and tried to get the organization to deal with your complaint or concern. All right, so that's that information. What is a false claim? It has to establish that the claim was false or fraudulent, that there was furnishing of inaccurate or misleading information, and that was and that the False Claims Act, a false claim, it has to establish that the claim was false or fraudulent, and it has to involve some inaccurate or misleading information. And then I wish they'd done this a little bit differently, but anyway, the False Claim Act has been extended to cover quality of care. That it's not enough that you bill inappropriately if you give inappropriate care. That's also part of a false claim or fraud or abuse. Another key part of this is the knowing standard. The provider must have knowingly submitted the false claim. The knowing means, or knowingly means, that they had actual knowledge of the information being false. They were acting in deliberate ignorance of truth, meaning that they knew the truth and they still did it anyway, or they were told that they needed to know the truth and they refused to do what they needed to do to be educated about preventing fraud, abuse, or submitting false claims. So basically, they're acting in reckless disregard of truth or falsity of information. As I talked about, the original False Claims Act was updated in the Fraud Enforcement and Recovery Act of 2009. Basically expanded the potential for liability under the False Claims Act and expanded government's investigative powers. And there was some statutory expansion of the False Claims Act before 2009, but 2009 really was a major update of the False Claims Act. So that's why it's here. The False Claims Act penalties apply to any person who knowingly presents or causes to be presented a false or fraudulent claim for payment or approval, regardless of to whom the claim was made. Definition of a claim was expanded to broaden the types of payments that fall within the scope of the False Claims Act. Again, it established that the penalties apply to any person who knowingly makes, uses, or causes to be made or used a false record or statement material to a false or fraudulent claim. It expanded the anti-retaliation protections for whistleblowers, those who do qui tam. It expanded the U.S. Attorney General's authority to issue civil investigative demands, and it broadened the federal government's authority to share documents obtained through subpoenas with qui tam relators and other parties. Another piece of legislation that we'll study multiple times and already have, but we'll study multiple times, is the Patient Protection and Affordable Care Act, or the ACA. This also had a couple of revisions to the False Claims Act in it. That's typically what the government does. They'll come up with a big piece of legislation and they'll tuck multiple things in it, some of what belong with it and some that don't. In this case, the ACA had a lot of other major provisions, but one of the things that were a couple of the things that were tucked into it had to do, again, with extending the False Claims Act. It allows private individuals more successful in filing false. It further amends it by allowing more private individuals opportunity to be successful in filing false claims lawsuits. It broadened the definition of original source to allow public disclosure defense to be overcome if individuals bringing suits possess knowledge that adds to publicly disclosed information, and it clarified the retention of overpayments. What could be retained in an overpayment? Another major piece of federal legislation you need to know about is the federal anti-kickback statute. This establishes criminal penalties for individuals and entities that knowingly and willfully offer, pay, solicit, or receive remuneration in order to induce business for which payment may be made under any federal healthcare program. This means the transfer of anything of value directly or indirectly, overtly or covertly, in cash or in kind. The violation constitutes a felony punishable by a fine up to $25,000, imprisonment for up to 5 years, or both. It clearly prohibits payments for patient referrals. That's what kickback is. Kickback would be providing incentives to providers to direct their patients to a particular clinic or use a particular lab, or that type of thing. That's prohibited. There are statutory exceptions that are created to protect legitimate business arrangements, such as discounts that are properly disclosed and reflected in the cost claim, payments by an employer to an employee for provision of covered items and services, very specific risk-sharing arrangements. There's only a handful. waivers of coinsurance amounts in connection with certain federally qualified healthcare centers. But again, it's these items are very few and they are very clearly defined for the most part. Safe harbors, that's a term that you might need to be aware of. Activities that are not subject to prosecution and protect the organization from civil or criminal penalties. That's a safe harbor. These include investments in certain large or small entities, investments in entities in underserved areas, and space and equipment rental. In those cases, those are safe harbors, meaning that they are not part of the anti-kickback statute, and it's okay to be involved in those kinds of agreements. But again, there's a lot of detail behind this law that it goes into as to what these are and how they work. So what do you need to know? The common theme is to protect certain arrangements in which commercially reasonable items or services are exchanged for fair market value compensation. Again, it's fair market compensation. It is not incentivizing patients. And that's where you get into that. Incentivizing people who can direct patients to your organization. So what are safe harbors when it comes to EHRs? Well, the safe harbor for EHRs, the intention behind it was to protect beneficial arrangements that would eliminate perceived barriers to the adoption of EHRs without creating undue risk that the arrangements might be used to induce or reward the generation of federal healthcare program business. So that's another example of a safe harbor is when it comes to EHRs. All right, let's talk money and penalties. The civil monetary penalties provide administrative remedies for all of these statute breaches, shall we say, or these statute for breaking these statutes. It authorizes the Secretary and Inspector General of HHS to impose penalties, assessment, and program exclusions on individuals and entities whose wrongdoing caused injuries to HHS programs or their beneficiaries. They can assess up to $50,000 per violation and treble damages. This is why it's so important that if you're in coding and you're doing audits and you uncover a consistent coding error that has been occurring, maybe it's with one coder, maybe it's over multiple coders, maybe it's the encoding software, whatever. But you find that you've got all these cases that have been billed inappropriately. That's why you've got to go to risk management. You've got to go to corporate compliance and talk with them and figure out how you're going to notify the government that this was an error, that you are correcting all of these. Because if you don't and the government finds it and that they are able to prove that it was done intentionally or that it was covered up, they can assess up to $50,000 per violation and treble damages, which adds up incredibly quickly, incredibly. So another statute we need to be aware of is the Stark Law. It's called the Stark Law, even though it's the Federal Physician Self-Referral Statute. It's referred to by healthcare organizations as the Stark Law. This prohibits physicians from ordering designated health services for Medicare and to some extent Medicaid patients from entities with which the physician or an immediate family member has a financial relationship. What this means under Stark Law is that if you're a hospital and you own a nursing home, you can't just refer patients to that nursing home. You have to clearly state that the hospital owns that nursing home. So for instance, because I've worked for organizations where this has been the case. In fact, the healthcare system I worked for in North Carolina, we had two skilled nursing facilities. And so the utilization review staff and discharge planning staff particularly, when they would go up to see a patient that was going to be discharged to a skilled nursing facility, they had to provide a list of all facilities within 50 miles of the hospital. And not only that, but they had to make it had to be on the sheet that they presented to the patient and the family, the fact of which two we owned and the fact that they were owned. We could not advocate that they use our facilities, our skilled nursing facilities. And same thing with physicians. If a physician owns an ambulatory surgery center or has a share in that, or if they have an immediate family member that has some shares in a lab company or like LabCorp or something like that, they cannot refer patients. They cannot do something that's going to benefit them financially because they have a share in it or because they have a financial ownership stake in it. Excuse me. So that's what the Stark Law is all about. There are some exclusions, and those are listed here. But basically, what it comes down to is if it's going to financially benefit the provider or the healthcare organization who is the owner or has a financial relationship with it, you can't refer that or automatically order that for patients that are in the Medicare Medicaid program. Hopefully that made sense. All right, Sherman Antitrust Act. You may have heard of antitrust. This is breaking up of monopolies. There's some discussion right now about major media corporations and whether or not they're monopolies and whether or not they fall under the Sherman Antitrust Act. That's where you might hear about it in the news at present. However, where it impacts healthcare organizations are in a couple of ways. One is mergers, where you have a hospital, a major healthcare system, and they're basically buying up all the hospitals in the area, so there's no competition, which leads to price fixing. That is illegal. And a lot of times you'll see with healthcare organizations that want to do mergers, they have to be approved by the Federal Trade Commission. Excuse me, the Federal Trade Commission is the one who oversees and investigates antitrust activities. The Department of Justice is involved in the enforcement part, but the Federal Trade Commission is the one who has to actually say, yes, you can merge or no, you can't. But that's typically with big healthcare mergers or significant joint ventures. But again, they're trying to make sure that patients and communities have choices for their health care, and so that you don't get into a price fixing situation or where everything in the area is owned by one healthcare organization. In Iowa, the two big players are Mercy One and Unity Point. But you also have Iowa City, you also have a handful here or there that are other things. But for instance, if Unity Point and Mercy One wanted to merge, that would absolutely go to the Federal Trade Commission, and odds are they would deny it because that would mean almost every, a significant portion of the hospitals in the state of Iowa would all be owned by the same company, and that would prohibit competition. So that's an example of where the Sherman Antitrust Act is used in healthcare today. It also happens sometimes where you get a healthcare organization in a specific area, and all of the physicians of a particular specialty are a part of that, or a part of that group. And there's concerns about price fixing or no competition that maybe, let's say that we'll go back to a general surgery example, that maybe all the general surgeons in a particular area are all part of one group. You have a general surgeon who comes to the area, doesn't want to join the group, wants to set up on their own, and finds that they're basically pushed out of town because they won't be part of the big group, and that the big group is, doing some things that inhibit that general surgeon from being able to be successful in their practice. That would be an antitrust kind of situation. So again, healthcare mergers, joint ventures, and credentialing and peer review processes have to be very carefully handled to avoid antitrust issues or allegations of price fixing or lessening of competition. All right, HIPAA. HIPAA expanded the Office of the Inspector General. Oh, mercy, yes. The Office of the Inspector General has grown in leaps and bounds, and the amount of money that they take back or issue in penalties is absolutely staggering. Every year, the OIG publishes their work plan, and in their work plan, they cover what they did in the last 6 months or the last year or even the last quarter. It just depends on what their report that they're putting out is, and it's just mind blowing. I don't think we do it for this class. I don't think I have you actually go out and take a look at it. But in other classes, we do. We actually go out to the OIG's website, and it's pretty eye-opening. All right, so what does the OIG do? They sanction authorities. They apply the penalty provisions beyond those funded by the HHS to include all federal healthcare programs, meaning TRICARE, VA, Public Health Service. They have strengthened their penalties for violations under Medicare and state healthcare programs. What other legislation might you need to know about? Well, there's the Deficit Reduction Act of 2005 that made compliance programs mandatory. I remember when that came into being, and all prior to that, they were voluntary, and everybody wanted to implement them because it was beneficial to do that. But once they became mandatory, everybody scrambled because they had to have certain components like employee education, written policies, and all of that. So it just basically really, really impacted. Prior to it, when it was voluntary, good organizations went ahead and did it. But once they realized that this act was coming and it would make it mandatory, then yeah, you saw a lot of activity going on. And so written policies had to contain specific items, and um, and the provisions had to have policies and procedures for detecting and preventing fraud, waste, and abuse. All right. All right, and then there's the Affordable Care Act. We talked about that a little bit, about how that expanded funding of enforcement efforts. It expanded RACs to Medicare's Part C and D and Medicaid, added penalties, required Medicare and Medicaid overpayments to be returned within 60 days. So healthcare organizations had to learn to cut those checks much faster. The OIG has a list of excluded individuals and entities that have been convicted of Medicare fraud, patient abuse or neglect, felony convictions related to fraud, theft, embezzlement, breach of fiduciary responsibility, or other financial misconduct when it comes to healthcare, or felony convictions for unlawful manufacture, distribution, prescription, or dispensing of controlled substances. And anyone who's been convicted of these things goes on the OIG's list of excluded individuals and entities. And part of the corporate compliance program is that I forget whether it's every year, the organizations that I've worked for that are really up on this, typically every 6 months, they're checking the list to make sure that there's no employees, no providers, no one who's in any way associated with a healthcare organization that's on this excluded list, because if they are, you cannot have them be involved. So what are high-risk areas for potential fraud and abuse? Well, definitely billing for non-covered services, altered claim forms, duplicate billing, misrepresentation of facts on the claim form, failing to return overpayments, especially within those 60 days, unbundling, which involves coding, billing for medically unnecessary services, overcoding or upcoding, billing for items or services not rendered, false cost reports. Every year, healthcare organizations, excuse me, the CFO has to file the Medicare cost report for the organization, and this is a big deal. Typically, it's a couple of years behind. So it's not like you end in December and in January you produce the one for the year before, because it takes quite a bit to get to that cost report. But they absolutely cannot file a false cost report. And so there are a lot of checks and balances in the financial side of healthcare organizations with these cost reports, going through, double checking, verifying, making sure that the information is as accurate as possible. And there's a lot that goes into the cost reports. All right. Healthcare fraud and abuse control programs. Their goal is to coordinate state, federal, and local fraud and abuse activities. They have partnerships to be proactive in identifying fraud. And what you may hear about are these HEAT teams, or Healthcare Fraud Prevention and Enforcement Action Teams. If you hear of a HEAT team, they are someone that they're a group of individuals from the federal government, from several different agencies that work together, that go in to identify significant fraud and abuse activities. They're great groups of people, but they're not people that you want to see on your doorstep. Let me put it that way. For CMS, they have fraud prevention system. They have the CERT program, the Comprehensive Error Rate Testing Program, CERT, and they have MACS and Program Integrity Contractors. They also have ZPICs and other ones that they are involved in looking at fraud and abuse. Then the Department of Justice is involved. They are the ones that go in on the investigations and the enforcement levels. They work in collaboration with a number of other federal agencies to investigate and prosecute fraudulent activities. Role of the Inspector General. The OIG is responsible to report program and management problems to both the HHS Secretary and Congress, along with their recommendations to correct them. Again, I talked about the annual OIG work plan, where you go out and you can see what they have been doing and what they have been collecting and bringing back in millions of dollars. And they also outline what they plan to do, what they plan to investigate and focus on in the following year. So it's always a good idea as a coder to go out and take a look at that and see what areas they're focusing on. They also publish fraud alerts and advisory opinions, which are helpful to understand kind of where they're coming from, what their thought process is, and what their expectations are. So corporate compliance programs, I talked about how those started in the 90s and have evolved since then. They have fines and penalties, but they reduce those if the organization has a fraud prevention and detection program in place and is actively working it. It has to be in place and actively working in order to reduce fines and penalties when it comes to sentencing. They are there to help organizations identify problems, improve performance, and avoid corporate integrity agreements. I have only ever worked for one organization that had a corporate integrity agreement, and that was before my time, I'm happy to say. And I hope they never ever go back to a situation where they need that. The corporate compliance programs require a compliance officer, just sort of like HIPAA requires a HIPAA privacy officer and a security officer. So who should have compliance programs in place? Basically, if you're any type of a healthcare organization or provider, you better have a corporate compliance officer, and you better have a compliance program in place. 7 steps for an effective compliance program include establishing compliance standards and procedures, assigning responsibility to oversee compliance with standards and procedures, using due care to avoid delegation of substantial discretionary authority to an individual. Make sure you have checks and balances in place, that one person doesn't have all the power or all the authority or all the knowledge, or only one person has access to the checkbook or to pushing the button to bill things. You want to make sure that you have checks and balances in place. Communicate the standards and procedures to all. Achieve compliance with the standards through monitoring and auditing. I cannot emphasize how important auditing is. It may be dull and boring, but it is the only way to make sure that you are doing what you're supposed to be doing, and to identify if there are issues. Identify them early. You know, the last thing you want is the government identifying your issues. It's much better for you to identify them through some type of monitor or auditing process and be able to get it fixed, corrected, and self-report rather than have the government come knocking on your door or perform an investigation. You want to enforce standards through appropriate disciplinary mechanisms, meaning that you treat everybody the same. If somebody has caused fraud and deliberate fraud, you want to handle that consistently, regardless of where they're at in the organization. And the same thing with abuse. If the first part of abuse is education, you want to make sure that everybody gets educated that falls into that category. And you respond appropriately to any offense detected to prevent similar offenses in the future. What are you going to do, first of all, to prevent them from happening? But what if they happen? How are you going to act in such a way that you make sure that they don't happen again, when you bring in new people or when people change roles, things like that. Compliance programs should be tailored specifically to the individual organization, but need to include elements that address the code of conduct, policies and procedures, education training, auditing and monitoring, offense detection and corrective action, and then enforcement of disciplinary standards. And that is it for Chapter 18. So, Chapter 17 and 18 for Week 15. And I will be back soon to talk to you about chapters 19 and 20 for week 16. Take care.